Hi friends from around the world. We have 3 cases today, 3 on procedural issues on Restitutio in Integrum. That is Latin, meaning that it comes from Roman law. It comes a long way, yes. It comes from Roman law. It is common sense and it should exist in your home jurisdiction as well. I wonder whether the application, the interpretation of how it is, applied for in practice is the same. You will tell me. Restitutio in Integrum is about absolute deadlines. You know the difference between absolute and relative deadlines. Absolute deadlines exist in the interest, in the public interest, so that the law is transparent and secure and applied to everybody in the same way. For example, absolute deadlines are the introduction of an appeal, the introduction of the opposition. So the opposition grounds, for example. So an appeal. Let's take an appeal. You have been notified of a decision from the appeal, from the boards of appeal, which is against you, notified. So there is a 2-month period where you can file the appeal file, so to say. So you can go to the general court, and then you have another deadline in order to file the grounds. Or you have an opposition division decision which has been notified against you. Okay, on that day you have 2 months in order to file an opposition, and you have another 2 months to file the opposition grounds, or the appeal grounds. So that is what the renewal. The renewal is something in the public interest. The renewal need to be filed and need to be respected because of absolute deadline. No, relative deadlines are different. They are more flexible. Relative deadline is, for example, you get an objection in a filing on a trademark, and this objection from the examiner says, well, I think that is against whatever absolute ground, and you have the possibility to comment on this in the next 2 months. So these 2 months is a relative deadline. Deadline, which means that if you answer this 1 day late, nothing happens. Or if you want to extend this month or so, you can do it with the motivation of a low standard by saying, well, for example, I have difficulties with the communication with my client and he needs to gather some evidence with regard to that, or the client is ill or whatever. So you will normally get granted this month or 2 months, whatever you need or a request for, in order to meet the request for the examiner. So these are relative deadlines. So you need to know this in order to get to Restitutio in Integrum, which is only for the absolute deadlines. And absolute deadlines, if you miss it 1 day, it's too late. That's it. That's all. Now, Restitutio in Integrum is an exception. There's an exception from the public interest that you have to meet the deadlines, right? So it is interpreted narrowly. That is an important issue. The standard of what can be accepted as motivation for Restitutio in Integrum are very high in Europe. It is not easy to overcome. So that is the first thing. Second thing, you can set back the clock, yes, but you cannot set back the clock to 0. No, you set back the clock only to the moment where the deadline expired, meaning that at the same time you have to file the Restitutio in Integrum request, and you have to meet the deadline with the action what was required by the deadline, right? The 2 things at the same time. And you needed to do it 2 months after removing the obstacle which hindered you, which was an obstacle for you to meet the deadline in the first place. Okay? So that's it on Restitutio and Integrum, what you should know. Now, you are interested in what are the cases and what is the practical importance with regard to your practice, law practice. And you may want to know, well, what is the practice in Europe in order to give your client the correct answer in case there's a problem in Europe. Or you may want to use the case law in Europe in order to present it in your law practice in the home jurisdiction and to evolve perhaps the jurisdiction there. First case, so it is about the missed deadline on presenting opposition grounds. The deadline was the 12th June 2019. And it was only presented on the 26th of June 2019, so 2 weeks late. And what was the problem? Well, the problem, according to the lawyer of the company, the representative, was that he himself had a sudden illness on the 12th of June. He had already much prepared of the brief of the opposition grounds, and it was ready to sign, but then he get into sudden illness, which was completely unforeseen, and he had to leave the office and had to go home, and that's it. And it was only after 14 days he get better, and he could made the filing and made the Restitutio and Integrum request based on his sudden illness. Now, what happened here is the administrative instances, they said, well, no, that is not sufficient. Well, one thing, what did he present it? The representative represented with regard to to its request of Restitutio and Integrum. Well, he mainly his evidence were two affidavits, solemn statements, that saying, well, I was ill and I couldn't do it and I had to go home, and that was the impossibility to meet the deadline. And he made the statement, and his wife, his spouse, made also a solemn declaration with regard to that, corroborating what has been said in the representative's affidavit. Now, the affidavit, we talked about this on Genuine News, etc., where somebody has an interest, and the boards of appeal and the opposition, they were not so clear on that, or they said, well, you have an interest. You as a representative, you want to win the case, and you had an interest in winning the case. So you have an interest also to make the correct statement, the statement which meets the criteria of Restitutio and Integrum in order to win the case afterwards. And that the probative value of that affidavit and of the spouse, well, they were not so sure about it, and it went up to the General Court. And the General Court said, well, it was a solemn statement of the lawyer, which is true, which may have an interest in the case, but it is not something comparable in the genuine use or acquired distinctiveness or reputation, where this, so to say, case law applies. The affidavit must be corroborated by objective evidence, and so this is not so far the case, because there's an ethical, professional responsibility of the lawyers. So they may inflict a criminal offense once they get caught in a false statement like that. So the bar of eliminating that statement is higher in that case. On top of it, it was the lawyer was the only person who could say something about it, because it was him who was affected. It was not something which he might say as hearsay from others. And the spouse is corroborating what he is saying. So he went not to a doctor to see a doctor and didn't get a medical certificate or something, because he knows about the illness best and what is best for him. So in the whole, the General Court accepted what is the Restitutio in Integrum request, annulled the decision and sent it back to the Boards of Appeal in order to make a new assessment. So that was positive, right? Let's come to case number 2. Case number 2 is a renewal request for a trademark. Renewal request. So within the renewal request, there is information from EUIPO to the client, which has a trademark which is up to renewal. And it says, well, it can be renewed until 26th of August 2008. So it's a case which is a bit older. 2008, 26th of August 2008. Now, the request for renewal was only presented in June 2009, so nearly 10 months after. And what was the reason? Well, the reason was what is about the renewal of trademarks? Well, it is about the filing date. So there has some importance with regard to that. You can file another, but the filing date you will lose. So if it is a renewal, you still have the filing date from the first filing, right? So it has its importance here. Now, the reason was twofold, according to the representative. The representative had a system, informatic system, which was put in place. Informatic system which alerts before the renewal and after the renewal. There were 3 alerts after the renewal and 1 alert before the renewal. Now, the first alert before the renewal was produced correctly, and the client gave its agreement on the renewal, and it was received by the clerk, by the officer, so to say, and the lawyer, they gave the order to the clerk to make the renewal of the trademark, and the clerk forgot about it. Human error. Second, the informatic system didn't work well because the alert number 2, 3, and 4 were not produced. So therefore, it was only 10 months later that the renewal has been filed at EUIPO. Now, it went up again to the General Court, and the General Court said, well, it's a human error. Human error is predictable because human error, all the time we have human error. So human error is not something which really can be excluded from the outset. It can be predicted that it will happen. Not predicted that will happen in that case or in that case, but it can be predicted that it happens because it happens all the time. So what you need is to have a second system which controls the human error. And that was not being the case here because the system was relying on one human, so to say, or human communication that this would happen. So here is a sorry from the General Court. And I have a third case. A third case is on designs, right? On designs, renewal of designs. And the renewal of designs is more disastrous than the renewal of the default of renewal than in the trademarks. And the trademarks, as I said, you can file again and you will have, a later deadline, a later filing date, sorry. Whereas in the designs, once you miss the deadline for renewal, you can introduce again a design filing, but you will be rejected because of prior art, even if it was yours. So that would be disastrous. You would fail all over on that design. And this was the case here. It was missed. The deadline for the renewal of the community design was missed. And there were, according to, it was the case was, so the design owner was Pirelli. And Pirelli had 2 agents involved. So one agent and the other agent had a sub-agent. There were 2 agents, and it fell between the rocks of the 2 agents. It was not clear what was the problem there. But the argument of Pirelli was, well, For me, I chose the agent 1 and agent 2 very diligently. So it cannot fall back against me that the agents, they were chosen with due care and they had no problem in the past, and so that would be sufficient in order to exclude to admit, so to say, the Restitutio Integrum. Pirelli, I have done all my due care with regard to choosing these agents. Now, the General Court took the position, well, sorry, that is not the case, and the same standard that applies to trademarks has to be applied here as well. Once you choose, so the due care and the due diligence with regard to the renewal of a community design must fall back on you, Pirelli, and on the two agents. So if the outcome is bad and one of the agent or the agents are, so to say, responsible and have not something to say with regard to the Restitutio Integrum, then it's gone. So the fact that you, Pirelli, acted in due care and due diligence, that is okay, but it's only okay for you. It is not sufficient in order to save the trademark, where you have problems in due care and due diligence with regard to the agents. So is it the same standard you should apply also for designs? Well, the design is more disastrous if you get past the renewal deadline, but it is about deadline, right? You cannot make one standard for one deadline and another standard for another deadline for the trademark renewal. I think that would not be a real possibility. But how is the situation in your home jurisdiction? I would be very much interested in it.